Hello, hello. We should be live and recording now. Maybe this will do it. Hello, hello. We should be live and recording now. And I'm just waiting to see if I actually pop up on my cell phone because... Oh, there I am. Now, let's see if I can hear myself. And I can hear myself. Phenomenal. So I'm going to be coming to you with all of the production value that you've come to expect from my videos, where normally I'm sitting in my car, but this time I won't be sitting in my car. I'm sitting in my living room. I have to warn everybody that I have hardwood floors and I have dogs with toenails, and my wife is in the kitchen making me something that smells delicious for dinner. So expect background noise and things like that. So today, what we're going to look at is Chillie Decastro's 3-part series on overturning Terry v. Ohio. Now, we might not get through all of it. I have a very low tolerance for stupid, unfortunately. And Chillie has a very high output of stupid, unfortunately. So I'm pretty sure we're going to get through the first 10-minute video. He's going to break down the case and the characters, the times and the culture around the 1960s. Okay. And the next one we have is going to be a comprehensive guide to understanding why we must overturn Terry. And then the third one is a breakdown of the Terry v. Ohio oral arguments. Now, this is the least important thing. The oral arguments are not at all relevant to what the actual case law is. Oral arguments are fun to find out like what the arguments for and against a particular outcome are, but they're not really so helpful in understanding the particular outcome. To understand the particular outcome of a Supreme Court case, you want to look at the actual opinion and you want to look at the syllabus to kind of give you a breakdown of what educated the clerks, the Supreme Court clerks who write the syllabuses probably had a good hand in actually writing the decision, and they are some of the best attorneys out there. And then you could also read the dissents, but the dissents really aren't going to be much help. So we're going to get into it here. I have turned up the speed to 1.5 times on all of them. I have not watched any of them. I did let the first one play while I was adjusting sound volume or sound settings, and I got to somewhere in here around 25 seconds. So I'm pretty much going in blind. There was nothing given to me during that time. I think it was going over like the location that this happened, but I wasn't really paying attention. I was looking at sound. Okay, so here we go.
Number 67, John W. Terry et al., Petitioners versus Ohio.
So this is everything you need to know about Terry versus Ohio. We are going to go over what the case is.
The facts in...
Somehow I doubt a 10-minute video is going to be everything you need to know about Terry versus Ohio, but okay. Well, actually, from here we have a good idea of who was on it. You do have a black Supreme Court justice, and then the rest were all white men. I believe this is pretty much the same court. The Thurgood Marshall Court is the one that passed the Civil Rights Act. So a lot of these guys were still on for the Civil Rights Act of 1965-ish.
In this case, this incident occurred at 2:30 in the afternoon, broad daylight, in the downtown section of Cleveland, Ohio. The police officer in this case, one Martin McFadden, noticed two Negro males standing at the corner of 14th Street in the city of Cleveland, where Euclid Avenue and Huron Road intersect. These two streets, if the court please, form a triangle at the apex of East 14th Street. The police officer was approximately 100 feet away from where these two men were. He said, well, to tell you the truth, I didn't like them.
Didn't like them?
Yes.
So for this case to continue, for us to continue down the road of this case, you first have to buy that Martin McFadden was a super cop and he predicted a stick-up. We have to start from there.
Whoa, wait, whoa. Whoa, Sally Jesse Decastro. No, he didn't say that he predicted a stick-up. He said he didn't like him. There was something about Terry and the other gentleman that Terry was with. Are you in a garage or a basement, bro? Anyway, I'm sorry. I got distracted. So yeah, he said he didn't like him. There was something about him he didn't like. That's what he said. He didn't say I automatically am predicting these guys are going to do a stick up. He said I didn't like him. So okay.
To have a case at all whatsoever.
No. Because he didn't seize them or search them based on just not liking them. He seized them and searched them based on articulated facts from which a reasonable person could draw the conclusion that crime was afoot. Or at least that's what the Supreme Court found.
What is that generally?
Oh, I probably should, let me just back this up a little bit. I probably should, as a disclaimer, state that, for the record, I am not a fan of Terry v. Ohio. I do not think that there should be any search or any seizure on any basis less than probable cause. I don't care how hard it makes it on the government. I absolutely do not care. The point of the Fourth Amendment is to protect you from unreasonable searches and seizures, yes. But it goes on to say that they have to have probable cause, a warrant based on probable cause. And I think it should be based on probable cause. Because once you start going into reasonable, the touchstone of the Fourth Amendment is reasonableness. Then all of a sudden you're allowing the court to basically backfill wherever it wants to. It can supply the reason. It can create a rationale for it whole cloth. Just, look, it's reasonable. It's reasonable to have inland border control checkpoints where they can stop you and demand your name and where you're going and your paperwork. That's reasonable. It's a short detention. It's a reasonable detention. You get that kind of crap. So I am on Chillie's side, believe it or not. I think Terry v. Ohio is a gross decision that is an affront to the Constitution.
Super cop, and he predicted a stick-up. We have to start from there to have a case at all whatsoever.
What kind of a neighborhood is that generally in Cleveland? A business neighborhood?
That is our downtown section, the busiest section of the city, Your Honor.
Downtown retail stores and offices and so on.
Yes, Your Honor. And the testimony of the police officer was that there was business as usual in the downtown center of the city. Stores were open. There were pedestrians on the street. The police officers stated that he positioned himself in the doorway of a department store by the name of Rogo. For a period of 10 to 12 minutes, he observed these two males at the corner. Alternately, each made 5 or 6 trips over to 2 stores located on Huron Road. He said that he didn't know whether it was the United Airlines store or the Diamond store.
We're going to go over the battle between Reuben Payne and...
We're going to go over the battle between the attorneys? I guess. I mean, I don't know why you would need to know about the attorneys, but okay.
Lewis Stokes. And really, Reuben Payne just lays a shellacking on Lewis Stokes. And Lewis Stokes lays a great big goose egg in the arguments for Terry.
They were standing.
Well, I mean, you're going to assume that he has a good argument to make. Unfortunately, the court at that time was basically going to go down the road of, the touchstone of the Fourth Amendment is reasonableness. And so what is an attorney going to argue? Look, here's the Constitution. It says probable cause. It says a warrant. And here the guy is searching and seizing my client. And the court's like, well, it wasn't that much of a search. I mean, he just patted down the outer clothes. I mean, it wasn't that much of a search. It was reasonable. What's the other attorney going to do? I mean, you can't do anything if the court's already made up its mind. Sometimes it's a misconception that there is an argument that is going to persuade people. Most people already have their understanding, and they're just looking for the arguments that will confirm their understanding of the law. That's why people listen to Decastro, is because he is telling them what they want to hear about the law. People are always they're always in my comment section going like, I don't understand why people listen to him. He's obviously an idiot. He obviously doesn't know what's going on. Well, yeah, but he's saying what they want to hear. That's the thing. I don't say what they want to hear, so they're not going to come and listen to me. They'll go and listen to him because he says what they want to hear.
On the corner conversing. Then, because of their not continuing in the flow of regular commerce, he observed one of the petitioners walk away from the other one and proceed approximately 100 feet west of the street.
Alternately, each made 5 or 6 trips over to 2 stores located on Huron Road.
He noticed the unusual activity of this petitioner peering in the jewelry store or the airline office there. That was something in the vicinity of the airline office or the jewelry store which excited the petitioner's attention in some manner or in some way.
When you listen to the Terry v. Ohio oral arguments, raw dog, just straight, they're only 1 hour, you'll
Raw dog, just straight. Well, you know, believe this or not, kids, the oral arguments were made after the petition and the response to the petition were made by the petitioner and the respondent, whatever you want to call them, the appellant and the appellee. So there is already a lot of case law that's been laid out. The facts were already laid out. These are just the lawyers basically trying to shore up anything that they have in their briefs. So, I mean, I wouldn't put too much stock in oral argument because, again, I think that most of it is just a just in case somebody might say something that might change somebody's mind, but it is few and far between.
You'll hear that the number of times that Terry, Katz, and Chilton went over and looked in that diamond store window, it exaggerates constantly throughout the entire trial. Of course, Louis Stokes never pushes back on this, and the only time it's ever mentioned is when Thurgood Marshall mentions it later in the trial.
He didn't
Well, so if you're just looking at or if you're just listening to these, sure. But the court actually came out with, well, let's pull up Terry v. Ohio, shall we? Let's pull it up. Roughly a dozen trips. 5 or 6 times a piece, roughly a dozen trips. So that is the finding of fact. I'm assuming that this finding of fact was made at the trial court level because you're not making findings of fact at the Supreme Court. So whatever the number is would be the number that was found at the trial court level. Alternatively, it might have come out at the appeals court level, but there is no fact-finding function of the Supreme Court. So these in here are the agreed facts. These are the uncontested facts, or they're the facts that were confirmed by the trial court.
turned to his companion on the corner, had a conversation with his companion. His companion, in turn, alternately proceeded up the street and conducted himself in the very same manner that they alternately.
Assembling, talking with others in a public street. Yeah.
In this way 4 or 5 times. That thereupon a third man came from across the street and had a conversation with them. After having a conversation with them, that the third man returned back across the street and stationed himself there. That these individuals then engaged in the conduct which I have described previously, 4 or 5 additional trips after that, making the total number of trips. They then went across the street. The three
making a total number of some 10 or 12 trips. So roughly a dozen trips. Okay. Do we have anything interesting going on here? Confirmation bias. Thank you, William.
men came together, at which time they were having a conversation, at which time the officer had concluded that they were casing the establishment for a stick-up.
I don't care if they went back and forth 4 times or 50 times or 100 times. We have the right to assemble in the United States of America. We have the right to assemble. The Cole.
Oh, wow. Oh, that's. Whew. All right. Well, I guess that solves it. We have a right to assemble, guys. Even if that assembly is conspiracy, engaged in a conspiracy to conduct armed robbery on a jewelry store, Chillie nails it. We have the right to assemble, guys. Well, I hate to break this to you, Chillie, but conspiracy to commit armed robbery is itself a crime. And things that could be construed innocently can, in Supreme Court case law, be used to establish probable cause and or reasonable suspicion. Things that could be construed innocently, like going for a jog as soon as you see the police, carrying an opaque bag in a high crime neighborhood. It's legal to be in a high crime neighborhood. It's legal to carry an opaque bag, and it's legal to start running as soon as you see the police. But when you add those 3 things together, that could be reasonable suspicion, at least according to the Supreme Court in Illinois v. Wardlow. So innocent, or things that could have an innocent explanation in and of themselves don't mean that there isn't reasonable suspicion or probable cause.
Colfax massacre was based on black people assembling.
We're talking about the Colfax massacre was based on black. Well, all right, Colfax. I have a feeling that Chillie. I mean, if you just look at his background, he is back in here. Where am I at? 419. Back in here, you see he has all these people who've been killed by the police. So I have a feeling that we're going to see a lot of that. So we're looking at the Colfax massacre. The 1873 Colfax massacre. Okay. It occurred on Easter Sunday, April 13th, 1873 in Colfax, Louisiana. And an estimated 62 to 153 black militiamen were killed while surrendering to a mob of former Confederate soldiers and members of the Ku Klux Klan. 3 white men also died in the confrontation. Oh, is this the one where they're always looking for the graves and they never seem to find them? I think I read something about that. Yeah, I think this is the one where they haven't actually found the victims yet. Yeah, okay. So 1873, that's what's screwing us, is something from 1873, and they were just assembling there. I remember something about there was going to be a hanging or something. I don't remember. Well, anyway, so if it was a black militia versus Ku Klux Klan members, then I don't think that's going to be a government action. Anyway, but I guess you shoehorned a Colfax massacre into a discussion of Terry v. Ohio. I guess the Colfax massacre was based on reasonable suspicion, right?
Massacre was based on black people assembling. Most of the 1967 massacres were based on black people assembling.
Okay, the 1967 massacres. Oops. Whew. Come on, do it. All right. That's not right. Massacres in 1967 by United States. Let's get down to 1967. Maybe, did he put something up on the screen? Is that Mississippi Burning? I have no idea what that is behind him. Lord. I told you I'd give you high production values. I don't know. Anyway, whatever, dude. Okay, so it was just all it was black people assembling, and there's nothing else to it. Just it was black people getting together, and that's why the government stepped in and searched them unreasonably and seized them unreasonably, and then apparently massacred them.
1967 massacres were based on black people assembling.
The police officer then says, I then went over to the three men. I said to them, I'm a police officer. What are your names? In the first instance, he said, they gave it to me quick. In all other places in the record, he says, they mumbled something. He said, at this, I then reached and got Terry. I spun him around, holding him in front of me. I then began to pat him down. He says, I felt inside of his top coat what felt to be the handle of a gun.
The cop testified, I didn't like him, so he ran over and grabbed him.
Well, no, I didn't like him, so then he observed him for a period of time, during which Terry and the other gentleman made between 10 and 12 trips to the diamond store to look inside of it, return back and converse with each other, and then they met with a guy somewhere in the middle of it. They met with a guy across the street. See, if you leave facts out, it becomes a lot easier to justify your narrative. If you oversimplify things, it becomes a lot easier to justify your narrative.
That's against your Fourth Amendment right. That's why Terry v. Ohio is the most liberty-stripping ruling that...
That's conclusory. That's conclusory to say, oh, well, he didn't like you, so he grabbed you. That violates your Fourth Amendment right. That is a conclusion. I mean, why are we 5 minutes into a video if all you were going to do is say, well, he didn't like Terry, so he grabbed Terry, and that violated Terry's Fourth Amendment right. Case closed. Except the problem for you is that the United States Supreme Court, which according to Marbury versus Madison, is tasked with being the ultimate arbiter of what the Constitution means and doesn't mean, the United States Supreme Court said, hey, it didn't violate your Fourth Amendment right. Now what, Chillie? Now what?
affects us the most. The exact same thing that happened to John Terry, that Martin McFadden did to John Terry, can now happen to you. It's the exact same thing. A cop can look at you and be suspicious of you, and it's always probable cause.
Well, first of all, oh, Jesus Christ. First of all, it's reasonable suspicion. The standard we're looking for is reasonable suspicion. The Terry search and seizure is based on reasonable suspicion, not probable cause. And the court laid out a rather vague, but at least an articulable standard for what the officer would have to show. He would have to show that there are articulable facts that when combined with his experience, he would be able to convince a reasonable man that there was crime afoot, or that there might be crime afoot. It's not a great standard. It's actually one of the more vague and nebulous standards. But there's a standard, and it's not based on probable cause.
This officer testified further, though, that he felt that they might be casing the place for a stick-up. Then the court then inquired of him specifically if he had ever, by the way, this police officer had been a police officer for 39 years.
Why is Lewis Stokes qualifying the cop to the judges? Why? Well, because it's a matter of record. When cops take the stand, the first thing that the prosecution will do, because usually it's the prosecution calling the cop, is they will establish that cop's bona fides. They'll be like, okay, so, where do you work? I work for such and such police department. How long have you worked for such and such a police department? This many years. Have you ever worked for any police departments before that? Well, yes, I have. How many years have you been a police officer total? Blah, 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 many years. They will qualify him. So it's going to be a matter of record somewhere. So he was qualified as a witness all the way back at the trial stage. I guarantee you. Because again, the attorneys aren't here arguing the facts to the court. They're here to argue the law. This isn't coming here on a mistake of fact. This is coming here on a question of law. Was Terry's Fourth Amendment right violated by what Officer McFadden did? What Officer McFadden did was established at the trial court. So when Terry made a motion to suppress that evidence, the gun, he lost at the trial court. And so the record from the trial court went with the case to the appeal court. And the appeal court looked at the record and they made their decision. And then it went from there up to the Supreme Court. And the Supreme Court is not trying to qualify McFadden.
And a detective for 35.
And see, if you knew a damn thing about the law, you wouldn't be asking about this. They're not going after the facts. They're going after the law. They're trying to figure out the law and what the law should be and whether or not his Fourth Amendment was violated.
Years.
What did they say? They said Martin McFadden had been a cop for 39 years. And they do this big emphasis on it. And so let's go back. He stops John Terry in 1963. So we can go back to 1923 is when Martin McFadden started being a cop, 1924. So what was going on in 1923, 1924? Prohibition. Before Brown versus Board of Education, police were the lynchmen. If you broke the black codes, police were the lynchmen in America.
Okay, so Officer McFadden is a bad person because he'd been a cop for 39 years. Again, the question for the court is, did the search and seizure of Terry violate Terry's Fourth Amendment right to be free from unreasonable searches and seizures? That's the question for the court. Not, is Officer McFadden a good person or a trustworthy person or anything like that. It's, did the seizure and search of Terry violate Terry's Fourth Amendment rights?
People, the public, would let the police force handle the situation. I believe that integration would not be immediate.
Black people in America aren't even free. So Martin McFadden...
He played a clip that was not from the 20s there to... So the civil rights movement was going on around this time, but it was mainly in the South. The North mainly supported the desegregation of the South. And, unless my math is horribly wrong, Chicago is a city in the North. So I don't know exactly why we're trying to shoehorn racism in here. Just if Officer McFadden had selected Terry on the basis of race, well, then there might be some issue there, because the 14th Amendment was, one of the purposes of it was to provide equal protection under the law, for which one of those things would be you have to be treated equally based on the basis of race. So you can't stop someone just because they're black. Now, I'm not saying that no cop has ever stopped a black guy just because he's black and then reverse engineered a justification for it. I'm definitely not saying that. But I'm saying that they didn't raise that as an issue here. So I don't know why Chillie's raising it.
McFadden and all the Supreme Court personnel, they're still being influenced by the Jim Crow Act. So these guys...
Is he aware that, was it Thurgood Marshall? I think it's Thurgood Marshall. Douglas descended, White descended. Thurmond? Marshall Oops. Oh, I can't remember how to spell it. Well, he's black. I guarantee you. 629. Let's see if I can't get a picture of it. Do I have a picture of it in here? Well, I've wasted enough of your time. I'm sorry. High quality production values.
These guys are raised, look at the years they're born. These guys are raised watching that Jim Crow Act to believe that black people are feeble-minded. So,
except for the black justice, right? Who apparently didn't dissent. Geez, how many times have I looked this up? Oh, so the case was heard in 1967 after the Civil Rights Act. So the Thurgood Marshall he became a Supreme Court justice in 1965. No, wait. In 1967. All right. So he was he's a black justice, and he was born in 1908. So there you go. Like, I don't know, but I guess he didn't dissent, right? I guess he didn't dissent. Let's see if he dissented. Oyez. 8-1 decision. What? There we go. 8-1. The dissenting vote was Douglas. So Marshall supported it. So the black justice was okay with it.
Martin McFadden starts being a cop in 1930, and then in 1954, black people are free. And 9 years later, McFadden sees...
I think black people were free before 1954. I'm pretty sure they were.
John Terry, says he didn't like how they look. Well, there's no shocker to that. That's not a surprise.
The court specifically...
Well, I mean, I question whether or not Terry and his friends were the only black people in the area. I mean, you could not like the way someone looks, and if they happen to be white, black, Asian, Mexican, whatever, I mean, it doesn't mean that you're not liking them based on the race. So this is Chillie filling in some of his predisposition there.
Asked him if he had, during his 39 years as a police officer, ever previously observed anyone casing a place. He said no, he had not. Asked if he had ever arrested anyone for casing a place. In his 39 years, he said that he had not.
He helps make the case for the state.
Actually, no, that doesn't help make the case for the state. That makes it a little bit weaker because remember, the standard that the court came up with was, based on the cop's experience and his intuition combined with the articulable facts. So by saying that McFadden had never seen anybody casing a place and had never arrested anybody for casing a place, that actually means that he didn't have that experience. So that kind of undermines some of the experience that he brings to the table with his 39 years as a police officer.
As a police officer, ever previously observed anyone casing a place? He said no, he had not. Asked if he had ever arrested anyone for casing a place. In his 39 years, he said that he had not.
He helps make the case for the state.
I then reached inside the...
Wow, I actually expected there to be some explanation about how he helped to make the case for the state. And again, the Louis Stokes is not introducing new evidence. He is going over the evidence that was established in the trial court.
Coat and tried to remove the gun. I could not remove the gun. I therefore took the entire coat off of him and then took the gun out of the coat. At this point, he says, I ordered the three of them into the store. As I walked through the doorway, I said to the store personnel, order the wagon. He later explained that ordering the wagon means you are then under arrest.
Just because a cop is suspicious of you doesn't give him the right to walk over and grab you. There's
Okay. If he has articulable facts and he believes that you are armed in the commission of a crime and he can articulate facts that would lead a reasonable person to believe that you may in fact be armed in commission of a crime, then he cannot just grab you, but he could also pat you down. That's what the Supreme Court held. This is where you argue why it shouldn't be that way.
There's no probable cause. If you
Again, we understand there's no probable cause. The court understands there's no probable cause. The question was, should you be able to grab someone without probable cause? And the court found that yes, indeed, if you have a reasonable suspicion, you can do it. That's the point of the case. Oops, fat fingered. So this is right now we're in the dissenting opinion by Mr. Douglas, where he says that it should be probable cause, not reasonable suspicion. And the standard that the court articulates up here is reasonable suspicion. And you're just articulating the dissenting opinion of Douglas at this point, except you don't understand that reasonable suspicion and probable cause are two different things.
Understand the Bill of Rights as written. This case should be thrown out right here.
Yeah, again, the Bill of Rights as written. Well, the Bill of Rights as written didn't apply to the states. The Bill of Rights as written applied to the federal government. The Bill of Rights as written doesn't allow the government at all to infringe upon your First Amendment rights. Congress shall make no law, right? Congress shall make no law. Well, even then, that's Congress, right? So can police make a rule? Can judges make an order? So this whole thing about, if you look at just the Constitution, just the Bill of Rights as written, it's a shaky argument, because none of, well, maybe the Third Amendment being an exception, but none of the others are taken like literally as written. They're all done as the courts have interpreted them, and that's based on Marbury versus Madison, like the first case you learn in law school, Marbury versus Madison. The Supreme Court gets to determine, is the ultimate determiner of what the Constitution means.
Once inside the store, the three men were ordered up against the wall, whereupon he then searched Chilton. Inside of Chilton's topcoat, he also found a loaded revolver. He searched the third male, Katz, upon whom he found nothing. He then caused these men to be removed from the haberdashery to Cleveland's police station. When they arrived
We need more haberdasheries, because a haberdashery is cool.
at the police station, they were then booked for investigation. Sometime late the next day, after having been interrogated the following morning, these men were then charged officially late the second day with carrying concealed weapons. The police officer testified further, reference to questions propounded to him having to bear on the question of probable cause. We asked him, did you know any of these men? No. Had you ever seen any of these men previously? No. Had anyone given you any information regarding them? No. He was then asked what had attracted his attention to them. He said, well, to tell you the truth, I didn't like them.
Looking at someone and saying, I don't like the way you look. What was the attitude and the sentiment of white people in the cities in the early...
No, the question, Chillie, is what was McFadden's attitude? Was McFadden a racist? That's what you want to ask, but you can't ask because it's not established. So now you're just going to ask people to formulate their own opinion now 60 years or so after the events took place as to what happened in Chicago on that day. Were people racist against black people? And did that motivate Officer McFadden?
early 1960s in America?
I don't like it.
Why not?
That's not Officer McFadden.
Oh, I just don't think it's right. If people in Mississippi are ready for that, then they'll say they are.
You agree?
And this was in Mississippi, not Chicago.
Yes.
I think that we were better off before it started.
Well, I think they should have stayed where they was at, just trying to stir up trouble, some of these. They should have stayed where they belong.
Well, I don't think none of us like it. I mean, I just think we ought to have open season on all of them.
Well, I don't know. I mean, it's not going to last too long before the people down here get a little antagonized with it, and they're going to take it into their own hands.
Up to the point where he
That was entirely, Chillie's just trying to shoehorn the race issue into this case.
spun Terry around. Had he done anything outside what a policeman might properly do? No, he had done nothing outside what a policeman might ordinarily do. Now, if then at that juncture he had reason to believe they might be armed, did he have to complete his questioning first, or could he frisk them? I would say, under the circumstances presented to me, that he did not, under those circumstances, have the right to lay hands on this citizen. And this would be because you do not think the record shows that he had any reason to believe they had weapons? No, that he didn't have. I'm saying that the point that you lay your hands on the citizen and you begin to exercise dominion over that citizen on the streets by spinning him around, in order for you to do this, that you must have the probable cause that is required to place a person under arrest, because this person is substantially under your custody, your dominion. And you mean he can't frisk for weapons without probable cause to arrest? Is that what you're saying? Yes.
Pay very close attention. This next part is where we all lose our liberty. Where
You're not going to comment on that last bit that you were playing there as to why Louis Stokes had a great argument, and that if the framers had intended police to have the ability to frisk you, they would have incorporated that into the Fourth Amendment somewhere?
the Fourth Amendment is washed away. Pay very close attention.
It's not washed away. It is substantially eroded. Not washed away. I mean, people still have searches and seizures set aside, suppressed, what have you, under the Fourth Amendment. It still provides you protections. And cops to this day still violate it. Oh, did I do something wrong there? I must have done something wrong there. Or did it just end?
Is where we all lose our liberty, where the Fourth Amendment is washed away. Pay very close attention.
It is a cliffhanger. Lord have mercy. All right, let's look at some of these. Let's see if there's anything that needs to be addressed in here. We'll get to the second video. He was actually squatting in an office space. He also tried to rent it out as though he was the owner. This is just sometime around 20 or 21. That's why he's couch surfing now. He's homeless. Yeah, he's a real winner. Prison warrantless butthole search is reasonable. So when you're in prison, you are a ward of the state, and you have lost most of your constitutional protections at that point. They can restrict your freedom of movement, your freedom of association. I mean, it's different. So Yeah, you can get butthole searched in prison. Anything else? Chillie's agreed to help News Now Houston with his lawsuit. Well, I'm sure that News Now Houston needs the help. Why can't you fast forward through the boring part of the video? Don't we all wish we could? The only reasonable person that would think two guys standing in front of a store would want to commit a robbery would be a cop. Well, the only reasonable person that would think that would be a cop. Okay. He'll claim Wiki is not law. I don't think I cited Wiki for law, but okay. Experience or doctrine. I'll bet Chillie would be okay. The way they looked, he means the way they were dressed. For example, a sunny day and a guy's wearing an overcoat with his hands in the pockets. Everyone else is in short sleeve shirts. Well, let's check that out. Well, we go over the time of day and everything like that.
In the afternoon, broad daylight in the downtown section of Cleveland, Ohio. The incident occurred at 2:30 in the afternoon, broad daylight in the downtown section of Cleveland, Ohio. The police officer in this case, one Martin McFadden, noticed two Negro males standing at the...
Let's see. Let's see if they actually set out when it was, because that might be a good point. October 31st, 2:30 in the afternoon of October 31st. I don't know. Let's go to Almanac. October 31, and this was in when? 1963. 1963. And this is 10. Short-term memory loss, 31. 31. So it was 50 Fahrenheit. So I mean, maybe up to 55. Wasn't raining. 10-mile-an-hour winds with gusts. I mean, I'm gonna go with he definitely could have. I mean, I might be wearing a top coat in that kind of weather. All right, so it looks like we caught up. Let's go on to video number 2. God, this is terrible.
Number 67, John W. Terry et al., Petitioners versus Ohio.
So this is everything you need to know about Terry versus Ohio.
I'm saying that the point
I thought the other one was everything we need to know about Terry versus Ohio.
that you lay your hands on the citizen and you begin to exercise dominion over that citizen on the streets by spinning him around. In order for you to do this, that you must have the probable cause that is required to place a person under arrest, because this person is substantially under your custody, your dominion.
You mean he can't frisk for weapons without probable cause to arrest? Is that what you're saying?
Yes.
Pay very close attention. This next part is where we all lose our liberty, where the Fourth Amendment is washed away. Pay very close attention.
Didn't your own court say this did not have probable?
Well, so this is Thurgood Marshall. So, okay. Didn't your own court say they did not have probable cause to arrest? As of this point, we are now talking about now. Okay.
Cause to arrest. As of this point, we now have.
The trial court indicated that at this point that there was not probable cause for arrest. The appellate court did indicate that there was probable cause for arrest after the frisk took place.
No, I mean, we haven't frisked him yet.
That is correct.
So he didn't have probable cause to arrest when he approached him.
I would agree with this.
And he didn't get probable cause until he put his hand on the butt of the gun.
He didn't get probable cause to arrest
him until he put his hand on the butt of the gun in his inside coat pocket.
No, sir.
Is that right?
No, sir.
Well, when did he get probable cause to arrest?
He received probable cause for arrest when he turned Terry around and ran his hands over the outside of his clothing and feeling a gun in the upper left breast pocket and indicating emphatically at that time that what I felt was a gun, a weapon.
Well, he didn't have it, as counsel for petitioner says, he didn't have it when he laid hands on him and turned him around.
I would agree with, he did not have probable cause to arrest.
Right.
I would agree that he would have probable cause to frisk or to lay hands on him at this point.
Why?
Because of the nature of the circumstances and protection of his own life.
The lawyer is telling the Supreme Court justice the constitutionality of probable cause. If the white cop is afraid for his life, that matters more than your civil liberties.
So, so you might have noticed there that the lawyer for the state was arguing that there was probable cause, because at this time it had to be probable cause. So the lawyer for the state was arguing it was probable cause, and the lawyer for the defense was arguing that it was not probable cause. And the court, on its own, sua sponte, came up with a whole new standard. And we're not even touching on that. Chillie isn't even touching on that. The court was like, yeah, you don't even need probable cause because, you had reasonable suspicion. So, it's just a minor inconvenience, and it's not really degrading to be spun around and patted down by the cops. And, it's just such a minor infringement on you that it can be justified by a minor suspicion that you're carrying a gun. And, we have to think about officer safety. So it's reasonable. It's a reasonable imposition on you. But our brainiac genius, having studied the Constitution for 20 years, misses all of that.
Because of the nature of the circumstances and protection of his own life. I find no problem with this.
And if someone is going to rob a jewelry store, then yeah, it does make sense. It does make sense that that person might be armed, because one would think that if you're going to rob a jewelry store, there might be an armed guard or something in there, and it might be more convenient for you to be armed if you're going to rob it. So I would understand why if Officer McFadden thought these guys were about to rob a jewelry store, that they might be armed. I would understand that. And if they're armed, he might want to disarm them before he gets hurt, doing whatever the hell he's going to do to arrest them.
Particularly because I do not ask for a different standard of...
And none of that's based on the color of their skin.
...probable cause, as it may relate to the right to lawfully arrest a person. I think that the quantum of evidence that is basic and essential under the circumstances to establish probable cause for the officer to arrest, for to stop a person, and to ask him questions, may be somewhat lesser in degree, but by the same token, it is probable cause under any circumstances.
That's incredible.
I just had a thought. Because I like to do that. Louis Stokes. Let's see who Louis Stokes is. Head of the Congressional Black Caucus. Yeah. Later served in the Army. Yeah. Okay. So, this might be a little weird here, but you've got a black man arguing the case in front of the Supreme Court, and the black man isn't arguing that McFadden was racist. I have not yet heard Louis Stokes argue that Officer McFadden was a racist or that he was motivated by race. Which just really gets the old noggin jogging about why Chillie is making this about race. Defendant black, ergo racism? I guess?
That's incredible. He's saying here that if a cop looks at you and he thinks that you could be armed, that's probable cause.
Was he saying that? Let's listen to it again. So remember, Chillie's thesis here is that the lawyer for the state, his argument is that if the cop thinks you're armed, that's probable cause. Let's listen to it and find out if Chillie's synopsis is accurate.
Civil liberties.
Because of the nature of the circumstances and protection of his own life.
See, that's a continuation of the previous argument where he had probable cause. The state said he had probable cause to the pat down. The state's argument was he had a probable cause to the pat down because of the nature of the circumstances and the threat to his life. So, okay, the nature of the circumstances. Well, what is the nature of the circumstances? McFadden thought they were going to rob a jewelry store. That's the nature of the circumstances. And the protection of his life would be, if they're going to rob a jewelry store, they're probably armed, right?
I find no problem with this particularly because I do not ask for a different standard of probable cause, as it may relate to the right to lawfully arrest a...
So the state is actually at this point asking for one standard of probable cause for searches and seizures and another standard of probable cause to arrest a person. And the Supreme Court basically acquiesces and just makes a different standard for a stop and frisk, i.e. the reasonable suspicion standard.
A person. I think that the quantum of evidence that is basic and essential under the circumstances to establish probable cause for the officer to arrest, for to stop a person, and to ask him questions, may be somewhat lesser in degree, but by the same token, it is probable cause.
The quantum of evidence. So what he's saying here is that there has to be some evidence for an officer to stop and frisk. And it may be lesser, you may need less evidence, but you need some evidence, and that some evidence is going to be probable cause.
Under any circumstances.
That's incredible. That's incredible. He's saying here that if a cop looks at you and he thinks that you could be armed, that's probable cause. That's
not at all what he said, Chillie. That's not at all what he said. He said there should be basically a lesser standard of probable cause for a stop and frisk. That you need some evidence that crime is afoot and some evidence that the person's armed. The quantum of evidence. That's the amount of evidence, Chillie, you imbecile.
That's basic. If the officer feels as though his safety is in jeopardy because he thinks that maybe you might have a weapon, then it's always probable cause.
And, if that were the case, then so many felon with a firearm would not be suppressed. They have to have something more than just, I think you have a gun on you. They have to have some reason to say, I think you're armed and in commission of a crime, and that would give them reasonable suspicion to do a Terry frisk. And they have to have some evidence they could point at, some facts they could point at to establish that reasonable suspicion.
It's always probable cause. And what's the results of making every officer have probable cause in their mind at all times?
But again, it's not probable cause, it's reasonable suspicion. Oh, they don't have it all the time. You moron.
It's that. That is the result of probable cause right there. You're looking at it. Here's the result of probable cause of an officer being in fear for his life at all.
Just pointing at random pictures, and all of these people had probable cause. I mean, I don't see your George Floyd on there, but they definitely had a probable cause to arrest him. But I mean, the fentanyl, the fake 20, they had probable cause to arrest him. But man, I don't know who all these people are. But apparently, the probable cause standard kills black people, and I guess I don't know. There's some white people on there too. I don't really know who all these people are. I got to be honest with you.
All times of you. And he says it. Louis Stokes, he nails it. That is exactly our culture today. That's exactly our...
Louis Stokes nails it. That's our culture today. Louis Stokes was arguing, both attorneys were arguing that probable cause was the standard, because up until this time, probable cause was the standard. It was the standard. Mapp v. Ohio, the Fourth Amendment applies. You need probable cause for warrant. You need probable cause for arrest. So Mapp versus Ohio established that the Fourth Amendment applies to the states. All right. So before Mapp versus Ohio, it was a question on whether or not the 14th Amendment had the Fourth Amendment apply to the states. Mapp versus Ohio solidified it. Probable cause was the standard. And I think Mapp versus Ohio was like just a few years before, I want to say early 60s. Mapp v. Ohio. Let's see what we got. 61, early 60s. So Mapp versus Ohio was the one that said the Fourth Amendment applies to the states. So both attorneys are arguing probable cause. The state has the worst argument, right? In my opinion, the state has the worst argument because the state's saying, we understand it has to be probable cause, court, but we think we should have a lesser standard of probable cause. It should take less to prove probable cause for a search. And the attorney representing Louis Stokes, the attorney representing Terry, he had a better argument because probable cause is probable cause. It's already established what probable cause is, and he had the better argument.
Our culture. You're always a suspect.
Louis Stokes was arguing probable cause. You need a probable cause for a search or a seizure. That's literally what he just argued, dude.
The same circumstances are indicated.
What do you understand probable cause to may happen?
The Supreme Court personnel are debating back and forth what probable cause is.
Oh, Jesus H. Christ. They're asking. So Payne, the attorney for the state, had just said there needed to be there should be a lesser quantum of evidence required for probable cause to pat someone down. And Hugo Black is asking, what do you understand probable cause to mean? Like what? Like probable cause has already been decided what probable cause means at this point in United States history. We already have the standard for probable cause. So Hugo Black is like, wait, what do you understand probable cause to mean? Because you're arguing for a lesser showing, a smaller quantum of evidence to show probable cause. So what do you understand probable cause to mean? This isn't some undecided thing. Probable cause has been around. I mean, it is literally in the text of the Fourth Amendment. I'm typing one-handed because I'm holding a microphone, so I apologize. Let's see when it was. When did they decide on the standard? Let's go through Wikipedia, I guess. Main article. History and development. English common law. Yeah. Illinois v. Gates. That was a much later case. Territory, Ohio. Nah. All right, so I'm not going to spend the time to go through it and look at it, but the text of it is the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So probable cause has been in the Fourth Amendment. I don't know exactly when they did it, but I mean, it's in the Fourth Amendment. It was established before Mapp versus Ohio, and Mapp versus Ohio was before Terry versus Ohio. So actually, I guess we could look at Mapp versus Ohio. And I want the case. And 75 years ago. So Boyd versus United States, 1886. Let's look for probable cause. Oops. No probable cause there. All right. Isn't this fun? I told you I'd have high production values. Probable cause. Roshan versus California is going to be probable cause. Footnote 9. There we go. 1952. So they dealt with it at least in 1952. It was probably before that. But anyway, you get the point. Probable cause has been decided already by the Supreme Court.
The Supreme Court personnel are debating back and forth what probable cause is.
They're called justices.
Probable cause is when you have broken the law, supported by oath or affirmation.
So probable cause is when you have broken the law, supported by oath or affirmation. Well, probable cause is when there is sufficient evidence that a reasonable person can come to the conclusion that a law was probably broken, and you are probably the person who broke the law. It's a very low bar to hurdle, and no one can put a finger on exactly what percentage of proof you need. Is it like with preponderance of the evidence? We know what that is. That is anything greater than 50%. So 50.0001% of the facts support you, compared to 49.9999% of the facts support them, you win. That's preponderance of the evidence. But the courts have never actually put a percentage value on probable cause. We know it's low, we just don't know how low. But no warrant shall issue but upon probable cause. So he's saying probable cause is defined by the actual text of the Fourth Amendment. No warrant shall issue but upon probable cause supported by oath or affirmation. So the probable cause has to be supported by oath or affirmation, but the probable cause does not have to be oath or affirmation. So it's, if something is supported by something else, that means that something else isn't part of the something. Like if your house is supported by a foundation, the foundation is different than the house. And it's part of the house, sure, maybe, I don't know. Maybe that's a bad analogy. But again, these are this is the high quality production value you're getting.
That you've created a victim. That's what probable cause is. There's no need to kick around what it is. You've broken the law and created a victim supported by oath.
The whole created a victim thing, that sounds very sovereign citizen-y. You don't necessarily need a victim per se. You can break the law and the aggrieved party could just be the state. Like disturbing the peace or something. There doesn't have to be a victim. Or littering doesn't have to be a victim. Speeding doesn't have to be a victim.
Oath or affirmation.
It's just Chillie inserting random Chillie shit in there.
If I may put it in my own language, I am saying that there was probable cause for the officer to interfere with their freedom of action at this point.
Well, that's what I say.
So Payne, the attorney for the state, is really trying to differentiate between probable cause and the amount of proof you need for an arrest, and probable cause, the amount of information you need to interfere, in quotes, with their freedom of action, i.e. seize them, but it's a lesser seizure than an actual arrest.
Interference with their freedom of action is not in a significant way at this time.
Well, that's what I understood from the argument from the use of probable cause. And what you're really doing is saying you don't have to change the labels. Still probable cause, and it's still an arrest. But an arrest for the purpose merely of asking a question, who are you and why are you here, is a different...
So the justices are already leaning towards, at this point, apparently, a reasonable suspicion standard. And the attorney hasn't quite picked up on that yet. And he's still saying, well, it's probable cause, just a lesser standard of probable cause.
Thing from an arrest for the purpose of taking the station house looking for crime, you know?
Do you hear what they're doing? They're trying to normalize that police should be able to run up and grab you if they're suspicious of you.
No. They're trying to figure out, the court is trying to figure out the argument that Payne is making, the attorney for the state. They're trying to figure out his argument. And apparently it's either has convinced them or is convincing them or what have you. I've listened to a few oral arguments by the Supreme Court, and to be perfectly honest with you, it sounds a lot to me, at least in today's day and age. I don't know what it was back in the 60s, but in today's day and age, it sounds more like the justices are trying to convince each other than to try to get convinced by themselves. The justices always seem to have an agenda when they're asking the questions to get the answers that they want. So I don't know exactly what the point of it all is, but there you go.
Ohio law, I could not agree with this concept because under Ohio law, the definition of arrest is by statute. Statute. And it contemplates
a statute. Jesus, Lord have mercy. So let's see his question again. Okay. By statute. By what? Okay. So there is a definition for arrest under the Fourth Amendment. And there might be a different definition for arrest in a state. Now, the definition of arrest that the Supreme Court has come up with is going to control with when the Fourth Amendment applies as to when you need probable cause. So while you may not have actually done by statute, by state statute, what is by state law considered an arrest, you may still have arrested someone enough for the Fourth Amendment to kick in. You may violate. So that's what the attorney's saying. The attorney's saying, well, there's a definition for arrest in the state, and what Officer McFadden did, according to the state, wasn't arrest because it didn't comply with the state definition of what an arrest is. And Hugo Black was like, what? Because there is Fourth Amendment jurisprudence at this point as to what an arrest is, what constitutes an arrest. And this, again, there's two parts to the Terry stop and frisk. There's the Terry stop and the Terry frisk. And both of them rely on reasonable suspicion supported by articulable facts that crime is afoot, right? So right now, they were dealing with the frisk. Now they're dealing with the seizure.
But forgetting Ohio law for a moment, how about for the purposes of the Fourth Amendment?
See, he just, well, forgetting, see, he's saying by what? And then he goes on to say, well, forgetting about Ohio law for a moment, how about for purposes of the Fourth Amendment? Because again, the Supreme Court's version, or the, I don't know what circuit they were in at the time. I'm just going to say aren't they the 11th Circuit or something now? I don't remember exactly what circuit Illinois is now. But anyway, whatever circuit they're in, that might have its own specific definition or whatever. Anyway, it doesn't really matter. Fourth Amendment is federal law, and Ohio law as to what constitutes an arrest is immaterial.
And it contemplates...
But forgetting Ohio law for a moment, how about for the purposes of the Fourth Amendment?
For the purposes for the Fourth Amendment, it would be reasonable action on the part of this...
Yeah, so this is where they're starting to get into reasonable suspicion. That's where they're coming up with the name.
Officer, and if...
Well, I thought you agreed with Justice White before that really reasonable action and probable cause are pretty much synonymous terms.
And see, the court is saying, wait a minute. I thought you were saying that you need a probable cause, and now you're saying you need some reasonable action. And that's why the court separated the two terms. Probable cause means something different now than reasonable suspicion.
The Supreme Court changed the meaning of words to create...
No, they didn't.
...the word detained. Because...
No, they didn't.
Seized is already in the Constitution. It means arrested.
There was a touching...
Well, no, any seizure doesn't mean arrested. You are seized for the Terry search and seizure. It's a Terry seizure. You are seized. You are stopped. You're not arrested, but you're stopped. You're detained. They haven't changed the meaning of it.
But in seizure and arrest, you may seize it because you seize something tangible. But that's not what you're talking about in the seizure of the Fourth Amendment at all. I thought it was an arrest. It's an arrest.
It is arrest that I understand that we are discussing.
If you shoot someone, you've seized them. For the purposes of the Fourth Amendment, shooting someone is a seizure. If the state shoots you, they have seized you under the Fourth Amendment. Isn't that crazy?
Yes, ma'am.
Well, an officer could very easily turn a man around without arresting him.
I agree with this, and this is the position that
Might
I
not
take.
be easy, depending on his size.
That he could very easily turn the man around, and some may term that as a seizure.
KKK member Hugo Black is trying to argue that seizing you is not a...
KKK member Hugo Black. I don't know. Is Hugo Black a KKK member? Oh, Lord. Just trying to shoehorn racism. Hugo Black. He was anti-Catholic and a member of the KKK in Alabama, from which he resigned in 1925. Having gained a reputation in the Senate as a reformer. For much of his career, he was strongly liberal. Korematsu, that was a terrible decision. Let's see. Well, I don't really care. Anyway.
Arresting you if it's not for the intent to take you to the dungeon. You're really not...
Let's go back over this again. I got distracted with him bringing in race to something that no one's discussed race on.
That seizing you is not arresting you if it's not for the intent to take you to the dungeon.
To take you to the dungeon. Oh, Freeman does that shit too. Oh, the cops aren't just arresting you, they're kidnapping you. All that bullshit. Just use the regular words. So, yes, they can seize you even if they don't mean to arrest you. That's what Terry determined. And not all seizures, even even if the officer has probable cause, he can seize you, but that doesn't mean he has to arrest you. He can seize you, while he's conducting his investigation. Because just because he has probable cause doesn't mean you're guilty. It just means that he has reason to believe that you're guilty. Like if he comes into the room and he finds you with a gun in your hand and at your feet there's a person who's been shot, I mean, he has probable cause to believe you might have shot that person, right? But then, you might have heard the gunshot or whatever, and you rush in there and it turns out the gun in your hand doesn't match the wound characteristics, yada, yada, yada. And it wasn't you after all. Hey, congratulations. So he may arrest you if he has probable cause. He may seize you and keep you there without technically arresting you, etc., while he's investigating. So it doesn't just mean getting dragged off to a dungeon.
You're really not seized unless you're taken to the dungeon.
Well, no, you are. You are seized. Like I don't understand why you don't understand words, Chillie.
He's trying to say, well, that's not what it means constitutionally.
Yeah, so seizure means a lot of things in the Constitution. There's a difference between seizing someone's stuff and seizing a person. And if you're going to seize someone's stuff, generally speaking, you have to have probable cause. If you're going to seize a person, you either have to have a reasonable suspicion at this point, thanks to Terry, or probable cause.
Supreme Court justice supposedly standing up.
Actually, technically, since they have at the border, they can seize you without either reasonable suspicion or probable cause. And at inland border control checkpoints, they can detain you momentarily without reasonable suspicion or probable cause. You got to stop and answer their questions.
For our civil liberties.
But I would not term it as a seizure of the person himself unless he has the intention of taking that person into custody, even though he...
That's the argument the state made.
...may lay hands on him at that particular time. The first seizure of the person was at the time that he ordered them into the store.
Seized equals arrested, detained equals seized. No, seized can be arrested or detained. Think of it as a big Venn diagram. You want to see some of my awesome paint skills? See, seized, see this is arrested. This is detained. And this is seized. Smiley face.
He took Terry and swung him around with no seizure of the person?
I think there was a temporary detaining or interference with his person.
He had his hands on him when he switched them around. Surely there was no seizure of the person.
But here again, we're dealing in simply semantic words.
No, I'm asking, that word's in the Fourth Amendment.
Agreed that it is, sir.
Play that back again. Listen to what they're doing. They're changing the definition of detained.
They're asking the attorney to make sure that he clarifies his position.
Because when detained means seized, he says, isn't that word in the Fourth Amendment? Against unreasonable searches and seizures? But now detained doesn't mean seized in what world? At the Supreme
It does. But see, what they're saying is that you have the right to be secure against unreasonable searches and seizures. And what they go on to say is it's reasonable to search and seize someone if you, for a pat down, a Terry pat down, a Terry frisk, and a Terry stop, it's reasonable because it's a short delay and you're not actually, getting down inside their skivvies or anything like that. It's you're patting down the outside of their clothes.
Court, at the Supreme Court. Because if you've been seized and you've been arrested, and you can't be arrested on reasonable suspicion, you have to be arrested on probable cause.
Right. You have to be arrested on probable cause, but you could be detained on reasonable suspicion.
That the defendant were conducting themselves suspiciously, and some interrogation should be made of their action. 5, there was reasonable cause in this case for the officer to approach these individuals and pat them down. Here is a decided attempt on the part of the trial judge to equate and balance the rights of the individual with the rights of the public and the safety that is involved herein as it pertains to the officer in this particular case.
I have a feeling that Chillie hasn't read the case. I think he's just listened to the oral arguments. Because he's placing a lot of emphasis on the oral arguments, and they're really not that useful.
The Terry laws that we live under today were not written by a legislator. Congressperson writes a bill that's a law, and then the president signs the law into effect. This is our Constitution.
Yeah, we'll see. It's in the Constitution. It's in the Constitution. The legislature didn't write the Constitution. The founders of the Constitution wrote at least the Fourth Amendment, and then the states ratified it. And it didn't become a law the way a legislative bill would become a law. But thanks for the insight into the three branches of government.
Constitutional process. The Terry laws were not signed into effect by the President of the United States. That's not what happened.
But see, they could not be signed. If let's just say, for example, that the Supreme Court had said no, it has to be probable cause. Fourth Amendment says probable cause. So the officer violated Terry's rights. Then the legislature could not go and write legislation that changed it to reasonable suspicion. The Supreme Court said reasonable searches are acceptable under the Fourth Amendment. And it was reasonable for McFadden to pat Terry down.
The Terry laws that we are forced to live under today were written by a Cuyahoga County trials judge named Bernard Friedman.
The trial judge.
No, it was written by the founders of the Constitution because they didn't specify well enough, and they gave the Supreme Court enough wiggle room to move away from the probable cause standard into this reasonable thing.
Judge made these remarks. A police officer cannot, as far as this court is concerned, and will not be permitted to stop and frisk an individual simply because he has a suspicion, a mere suspicion, unless there are reasonable circumstances justifying the frisk. When the circumstances justify, and there is reasonable suspicion, and for his own personal protection, he may frisk to determine if there are weapons for his personal safety. The officer assigned in the area which he had been placed, doing the job he had been doing, and had reasonable cause to believe and to suspect.
Probable cause is not probable cause to see or probable cause to believe. That's not possible. How can probable cause to see be supported by oath or affirmation?
The probable cause has to be supported by oath or affirmation. The probable cause is based on what you can see or hear or otherwise sense. And then you write down your oath or affirmation to the judge, and the judge will then issue the arrest warrant, etc.
The cop swears, he promises that he believes he was in danger. So your civil liberties have to go.
No. If that's the way probable cause worked, then everybody could get arrested just by the cop saying, I thought I was in danger, but it doesn't work that way. It literally doesn't work that way, Chillie.
That the defendants were conducted.
I think that probable cause is a bit too nebulous, and I think that a lot of judges rubber stamp probable cause. I really do, and even with that in mind, it never comes down to a cop saying, "Oh, I felt like he might be carrying a gun," and so then the judge signs it off. And if that does happen, it's probably going to get overturned. I've never seen a cop just saying, thought he had a gun, without anything else, and have that justify probable cause for an arrest.
Conducting themselves suspiciously, and some interrogation should be made of their action. There was reasonable cause in this case for the officer to approach these individuals and pat them down. Here is a decided attempt on the part of the trial judge to equate and balance the rights of the individual with the rights of the public and the safety that is involved herein as it pertains to the officer in this particular case.
This next part is where the Supreme Court personnel will inject that this entire thing is about officer safety.
They're called justices, you moron.
And here there is no suggestion, is there, that the policeman had any basis for fear as to his own safety? Am I right? That there's nothing in the record that indicates
There's
that?
nothing in the record whatsoever. I don't understand your answer to Justice Fortas when you said there's nothing in the record to indicate that the policeman didn't have concern for his own personal safety, because I thought he said that based on his intuition, he thought these people were casing a place in order to rob it. Isn't that what he said?
This is what he said.
Well, presumably then they would be armed, and the minute he walked up and talked to them, he would quite reasonably be concerned for his own personal safety, I should think.
Well, police officers are very often in a position where they might not be able to make an actual arrest, but they are in a position of great danger. And where they are in a position of great danger, are they in a position to protect themselves from violence by looking into the situation to see if anyone is armed to do the violence?
Yes, Mr. Chief Justice, he certainly has a right of self-defense, and he has a right to protect himself.
Just atrocious.
Well, I don't know with all the cutting that he did in there exactly what was going on. But yes, officer safety does come into it. If you're going to frisk someone, or if you're going to seize someone, the court thinks you should be able to frisk him if you can reasonably if you can articulate reasonable facts, or if you could articulate facts and have a reasonable suspicion that the person is armed, then you could pat him down. You don't just get to do it just on just your suspicion. There do have to be some articulable facts that will support your reasonable suspicion.
Listen to Louis Stokes.
Whether with or without reasonable cause, he thought or suspected that these were armed robbers about ready to hold up a place. I suppose if you walked up to such people and began asking them embarrassing questions, you might have some little concern for your safety if you bona fide believe that they have weapons on them.
Well, so you can see that this much was in the record, that he thought, whether with or without reasonable cause, he thought or suspected these were armed robbers about ready to hold up a place. Let's not skip that, Chillie. He thinks these guys are about to commit a crime. He thinks crime is afoot, about ready to hold up a place. So these are people that the officer, according to the court, reasonably believes, or may or may not have reasonable cause, whatever that is. I think he means probable cause. But the officer thinks these guys are about to commit armed robbery. And if he's going to go up and talk to them, he might have some concern if you believe that these people are armed, i.e., about to commit armed robbery. It's part and parcel. You don't have armed robbery without being armed. I don't know why this doesn't make sense to Chillie.
He thought or suspected that these were armed robbers about ready to hold up a place. I suppose if you walked up to such people and began asking them embarrassing questions, you might have some little concern for your safety if you bona fide believe that they have weapons on them. Now, that much is in the record, isn't it?
Yes, sir.
No, is that so? Excuse me, but is that so? Does the record show that he thought these men were armed before he put his hands on them?
Yes, he says that he thought they might be casing the place, and I felt that they might have guns. He
said he testified to that fact.
Yes, he did.
Don't you think he'd be...
See, the reason why the court is going on about, yes, he testified to that effect, that means there's evidence on the record. Because, again, they're not... If there was nothing in the record to support that inference, then the court wouldn't consider it.
Justified in the first instance in confirming whether or not they did have weapons before he went on further to interrogate? On the premise that it was reasonable for him to think that they had weapons.
He skips around a whole lot. It's hard to follow with all these jump cuts that he's making in the testimony.
Take a situation of this kind where a police officer sees someone acting very peculiar.
Down here, you see where it says 2651. It's jumping all over the place. So there's going to be some questions or some answers and more questions. So watch it. It's 1706. I went back 10 seconds and we got back, 6 minutes?
On the premise that
that was a jump.
It was reasonable for him to think that they had weapons.
That was another big jump. We're at 2643.
Take a situation of this kind where a police officer sees someone acting very peculiar. Might not be in connection with any information he has about any crime. Maybe the person is
Jesus Louises.
Situation of this kind where a police officer sees someone acting very peculiar. Might not be in connection with any information he has about any crime. Maybe the person is abnormal mentally. Maybe he thinks he's insane, and he wants to talk to him. But the man shows indications of he thinks of violence, and he wants to be sure that he won't be attacked when he goes to talk to him. And he goes up to speak to him, and also ascertains whether he has any weapon on him. Did you think he had a right to do that? As a matter of probable cause that he might be injured himself if he doesn't take precautions.
So that was what we like to call a hypothetical. And the court in this case was exploring the limits that these two attorneys were willing to put on the probable cause in their arguments. Now, obviously, Stokes placed different limits on it than Payne, the attorney for the state, but the court is going to ask them hypotheticals because that's one way of figuring out whether or not this makes sense. Because if the court can come up with a hypothetical, i.e. where someone is just mentally unbalanced, they're not committing any crimes. The police officer doesn't think that they're committing any crimes, but he thinks that maybe they have mental problems. Would that, Mr. Stokes, would that justify a search?
A police officer would do this under these circumstances if he felt himself to be in any type of danger, that he would conduct a search for the purpose of protecting his own life in a possibly dangerous situation.
You don't tell the Supreme Court that you're arguing that police shouldn't have the right to run up and grab you and then say, well, this is what a police officer would probably do anyway.
Well, but I am saying that we cannot, merely because of that type of situation and not being what is required by the Fourth Amendment, we can't give sanctity to it by way of saying, since you did find this product, we're going to permit it into evidence. So what Stokes is saying is that policemen probably would do that, but we would suppress the evidence, and so it would not be able to be used to convict the person for carrying a concealed weapon or something like that, which is your remedy for a violation of your Fourth Amendment right, is to have that information, that search or that seizure suppressed. And then the fruit of the poisonous tree, blah, 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 and all that other fun stuff. So what Stokes is saying is that, sure, the officer could search. I mean, if we're concerned about officer safety, let them search, but then suppress the evidence if they don't have probable cause. Let the officer be safe, but don't let them use that against you. Don't let them use that as a pretext, as a justification for an illegal search.
Life in a possibly dangerous situation.
You don't tell the Supreme Court that you're arguing that police shouldn't have the right to run up and grab you and then say, well, this is what a police officer would probably do anyway.
And Chillie did not understand that. Chillie completely missed that entire argument. The guy's a fucking brick. He's dumb as dog shit. Pardon my French.
Mr. Dessert, I'm sorry if I'm giving you the impression that the police officer cannot ask him a question.
I said, can ask him a question, but cannot get an answer and do nothing about it.
He can arrest him if he chooses.
He can arrest him. Before he doesn't choose to arrest him.
Then
he wants to do something short.
And I don't think he has that right.
If you read a little biography on Hugo Black, he said that he left the KKK. This is him in 1968.
Oh, we're going to go on to the next show. Oh my God. I don't know if I can do this. Oh, this is hard. Anybody still there? I guess people are still here. All right. I guess I'll do this. I'll take one for the team. Oh, Jesus. You know, there are some situations where a person is so stupid that you feel like you've got to go all the way back and reinvent the wheel just to explain to them from the very basics. Oh, it's just so hard and boring.
Number 67, John W. Terry et al., petitioners versus...
That's precisely what I'm saying.
Hugo Black is born in 1886, 10 years before legal segregation in Alabama. There's
he's a terrible person.
16 lynchings in Alabama before he's 10 years old. And then in 1896, when he's 10, legal racial segregation begins, the beginning of Jim Crow laws. And
yeah, he's a terrible person. Whatever. But explain to me how his legal reasoning was bad. And let's just pretend. Let's just pretend that Hugo Black, we just discard his vote. So instead of being 8-1 in favor of Ohio, it would be 7-1 in favor of Ohio. Then what, Chillie? How are you going to get rid of at least? Well, how are you going to? Well, you can't even get rid of. You'd have to get rid of another 6 justices in order to have it be 1 versus 1 and a split decision. Oh, the fucking idiocy.
And what has Hugo Black seen his entire life in Alabama? The Jim Crow Act, which means black people are feeble-minded. Their brains haven't evolved all the way. He's a senator of Alabama from 1927 to 1937. Hugo Black was appointed by Franklin Delano Roosevelt in 1937.
Blah, 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 blah.
Civil liberties to black people. The Supreme Court has not applied civil liberties to black people. So in 1968, that's the reason why you hear Hugo Black saying the things he's saying. Of course black people have to answer to police. His entire life.
He doesn't say black people. He didn't say black people have to answer police. Holy shit. Oh.
They haven't had a Fifth Amendment right. It's a shocker to him to hear that black...
But do you understand, Chillie? Do you understand that the decision in Terry v. Ohio applies to seizures of white people? It applies to seizures of Asians. It applies to seizures of Hispanics. It applies to everybody in the United States.
Black would not have to answer questions.
Map v. Ohio. Let's go to Map v. Ohio. This is Map v. Ohio. Let's view the case. Yeah, reload. All right. And let's see if we have a dissenting opinion by Black. Black concurred. So Black was one of the justices who agreed that the Fourth Amendment applied to the states. And I hate to break this to you, Chillie, but the gal in Map v. Ohio, she was black. She was black. Where is she? I saw pictures of her. I saw a picture of her. Dalry map. Pictures? I don't see pictures of her, but it looks like this is a black woman. She looks pretty black to me. No offense to her. She is a black woman. And Justice Black concurred in the decision, which means he agreed with it. He just wanted to put his own little spin on it. So there you go. Now, how are you going to justify that? The KKK member decided that a black woman in Ohio had a right to, they had to have probable cause to arrest her. How does that make you feel, Chillie?
Police. I mean, go back and listen to what he says here.
I guess he wasn't a racist when he decided the Mapp versus Ohio decision 4 years earlier, but then he became a racist again just in time for Terry v. Ohio. Because the outcome, just because a black guy was disadvantaged by this particular outcome, it means that he had to be motivated by racism.
Here.
He wants to do something short, but cannot get an answer and do nothing about it.
Suppose he wants to do something else? What is that? What do you mean do something else?
What do you mean? Well, let's go back through it, I guess. It's good. Suppose he wants to do something else. Let's go back through it. What came before suppose he wants to do something else? Suppose he wants to do something else short of arresting him. So if I remember correctly, in the previous video, we were going over this very line of questioning. All right. I said, can ask him a question but cannot answer it and do nothing about it. Well, let's go back a little bit more. Mr. Justice, I'm sorry if I'm giving you the impression that a police officer cannot ask him a question. Then Black says, I said can ask him a question but cannot get an answer and do nothing about it.
That the police officer cannot ask him a question.
I said can ask him a question, but cannot get an answer and do nothing about it.
He can arrest him.
He can arrest him if he chooses.
He can arrest him. Suppose he doesn't choose to arrest him.
Then
Suppose he wants to do something short.
But supposing he doesn't choose to arrest him, suppose he wants to do something short of arresting him. So Hugo Black is saying, well, what if the cop doesn't want to arrest him? What if he wants to do something short of arresting him? Then Stokes says, well, I don't think he has that right. So suppose he wants to do something short of arrest him. And then obviously it jumps to
He wants to do something short, but cannot get an answer and do
police brutality.
Suppose he wants to do something else? What is that?
Something short of arresting him. Something short. See, that's an arrest right there. That appears to be an arrest. It might be a detention, but that appears to be an arrest. That appears to be an arrest. He's putting handcuffs on him. It's probably an arrest. I don't know what this is up here. I don't know. I don't know what's going on there.
What do you mean do something else? What does that mean exactly? What does that mean exactly? What does that mean exactly, Hugo?
What does it mean exactly? What does it mean exactly?
What do you mean by that, Hugo? Hugo, what do you mean by that? What
Jesus, he's not going to answer you, Chillie. He's dead.
do you mean by that? Well, we know what he means by that.
Well, we know what he means by that. Oh, really? Do we? Tell us. Tell us, Chillie. What does he mean by it? Oh, you're just going to insinuate that he's a racist. But he wasn't a racist for Mapp. Weird.
Can't ask him a question. We cannot get an answer. And nothing about it.
You can't talk about Terry versus Ohio unless we talk about the Warren court. Earl Warren is facing impeachment by the police. They're picketing up and down the freeways saying impeach Earl Warren because he passed Mapp versus Ohio, which is the start of the exclusionary rule. That police can't just run roughshod over your civil liberties and then present evidence. It's called fruit of the poisonous tree. They got evidence off of you by violating your civil liberties. Mapp versus Ohio stopped that, and the police hated him for it. They hated Earl Warren for doing that. You can hear it when he talks. You can listen to his voice during the Terry trial that he is taking a dive, essentially.
Folks, I wonder if that would be broken down a little. I wonder what you would say to this. Of course, a police
I don't think so, Chillie.
officer does have the right to investigate the crime. And this police officer, in this instance, had the right to investigate crime.
What was John Terry's crime? What did he do wrong? He was walking around on the street in the daytime talking to other people. It's 2:30 in the afternoon.
Conspiracy to commit armed robbery. Conspiracy is when when two or more people get together for the purpose of committing a crime. That's conspiracy. Now, they don't actually have to complete the crime in order to be guilty of conspiracy to commit a crime. They just have to take a step in furthering the crime. And what is the step they took in furthering the crime? Casing the joint. Christ, Chillie, you're a retard.
He's walking around on the street speaking to other people. And they had
Conspiracy.
a conversation. And then he went over and talked to this man. And they had
Further conspiracy.
a conversation. And then he stationed himself over there.
He did see what...
Yeah, conspiracy. Conspiracy to commit armed robbery.
well, one might well say, were suspicious acts on the part of people whom he thought might be preparing to commit a crime. He had a right, did he not, to pursue that farther, to determine whether or not he would have probable cause, perhaps.
He had a right to investigate? Okay.
For an arrest.
He said that police have the right, do they not, to walk up to you as you're minding your own business and investigate you.
No, he didn't say that. He said he had a right, did he not, to pursue that further to determine whether or not they have probable cause, perhaps for an arrest. He's saying, do they have the right to investigate?
Perhaps for an arrest.
He said that police have the right, do they not, to walk up to you as you're minding your own business and investigate you. No, Earl.
Well, okay. Why can't they walk up to you and start asking questions? Why not? As long as they're not seizing you, sure, they can. They can walk up to you and ask all the questions they want. It's a free country, last time I heard, and police can exercise their First Amendment right to talk.
No, they don't. And why does he think that way? He's born in 1891. Earl Warren is supposed to be the defenders of our civil liberties, our right to be free. And instead, he's saying, don't police have the right to walk up to you? And
we just went from Warren is catching a lot of shit for Mapp v. Ohio to all of a sudden Warren is now against Mapp v. Ohio or something.
Question you on the street? That's what he just said.
Pursuant to that,
yeah, they could walk up to you and question you on the street. You don't have to answer. And unless they have reasonable suspicion, they can't detain you. And even if they detain you, you still don't have to answer. And they can't arrest you without probable cause. And if they arrest you, they have to read you your Miranda rights before they question you. And one of the Miranda rights that they read before they question you is that you have the right to remain silent.
He went to talk to these men. Now, because of the nature of the crime, that he suspected a robbery, he felt that when he went into the company of these three men against himself alone.
Armed robbery is not necessarily officer safety. It is one of the things the court considered.
That he was in a dangerous position.
No, McFadden never said any of that, Earl Warren. You did. You made that up.
No. McFadden suspected that they were about to commit armed robbery. He suspected that, which means he suspected that they were armed, which is a prerequisite for committing armed robbery. Fucking Christ.
You made that up with the other white Supreme Court justices. He never...
And the black Supreme Court justice, Chillie. You got to remember, the black Supreme Court justice also concurred in the opinion, or he joined in the majority opinion.
Said he was in fear for his life. It was the middle of the afternoon on Halloween.
No one said he feared for his life. He would naturally be concerned that the person was armed, which is why he frisked him and the other guy.
There were hundreds of people around. McFadden never feared for his life. You guys created that.
Then why did he frisk him, Chillie? Why did he frisk him? Why can't we draw a reasonable conclusion that Officer McFadden thinks they're armed and might want to frisk them before he deals with them?
You made that up. It's not in any transcript. McFadden never says he was in fear from his life from three black guys. It was two black guys and one white guy named Katz.
And that therefore he had probable...
So... Jesus Christ.
Cause to see if they had weapons on.
I'm pretty sure that Katz Katz also had a gun on him. And where are we at? Terry, Ohio. Katz. Oh, no weapons were found on Katz. Okay. Well, maybe it's just racism that Katz didn't have a gun on him.
Not because he had probable cause to believe they committed the crime, but because in investigating the matter, he had probable cause to believe that his life was in danger.
I think it's important that you understand what...
Well, I don't think he ended up having probable cause. And then it goes on to say, hold on a second. It goes on to say, under the circumstances, would you think that he did or did not? So it sounds like to me he was, come on, back up. It sounds to me like he was posing a hypothetical. Under the circumstances, would you think that he did or did not something, whether he was in a position, blah, 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 only if we're not, blah, blah, blah. So this sounds like some sort of a hypothetical.
Not because he had probable cause to believe they committed the crime, but because in investigating the matter, he had probable cause to believe that his life was in danger.
I think it's important that you understand what probable cause is. Probable cause is when you have broken the law. That's what you can get arrested for. Probable cause supporting...
No. Probable cause does not mean you have broken the law. A cop can have probable cause that you have broken the law when, in fact, you have not. Again, go back to my analogy or my hypothesis, my thought picture of a person standing over a body that's been shot holding a pistol. Could the officer have probable cause that the person holding a pistol over the body of a person who's been shot committed a crime? Yes. But does that mean that the person who's standing over the body of the person who's been shot holding a pistol, does that mean that person committed the crime? No, it does not. That's why there is a different standard of proof required in court in order to be convicted of it. Probable cause does not mean you have broken the law. Probable cause means there's probable cause that you may have broken the law. A law was probably broken, and you probably did it.
By oath is when a cop sees you break the law. Or
a cop doesn't have to see you break the law. The oath or affirmation means that in order to get in order to get an arrest warrant or a search warrant, the cop is going to have to give an oath or affirmation, or it could go through a grand jury. But the search warrant definitely has to go through oath or affirmation.
You created a victim out of someone, you assaulted them, and they called and they're swearing by oath that you can...
No. The victim doesn't have to swear by oath in order for a cop to have probable cause. If a victim looks pleadingly at the cop with a gunshot in their neck and they can't speak, they haven't said anything, but the officer at that point has probable cause to believe a crime has been committed. And now all he has to do is narrow down who probably committed it.
Committed probable cause and you broke the law. I just want you to understand, probable cause is when you have broken the law.
It is not. It is not. You dummy. You dummy McDummerson.
Crossed on a red. Someone called and said that you...
Oh, Jesus Christ. It's stuff like this that just... Oh. Sorry.
Assaulted them. Earl Warren saying that the cop has probable cause to see is actually impossible. The words don't make sense. He's making things up as he goes.
Yeah, a hypothetical is probably going to be made up.
Under those circumstances, would you think that he did or did not have...
See, under those circumstances, under the hypothetical that I've just presented, do you think he did or did not have the right to ascertain whether he was in a position of danger by seeing if they had weapons?
A right to ascertain whether he was in a position of danger by seeing if they had weapons.
Only if we're going to relax the standard probable cause as we know it under the Fourth Amendment.
As you can hear, Earl Warren...
Yep.
Is doing absolutely everything to work against our civil liberties to be free. He's working...
He asked a question, you stupid idiot.
On the side of officer safety that was never brought up.
He asked a question, you moron.
McFadden had zero fear of those guys on the street. It was broad.
Oh, show me in the transcript where Officer McFadden testified that he had zero fear of those guys. Show me.
daylight, he felt completely entitled to walk up
He's a cop. Yeah, cops feel completely entitled
to them and bully them and push them around. It was never about
Congratulations, Chillie.
officer safety. So it's astonishing to listen to Earl Warren.
Okay, Chillie. If you rub your two synapses together long enough and hard enough, we might be able to get this through to you. When the Supreme Court makes rights and opinion, and they make a ruling, they look at the record beneath them, and they can make logical inferences based on that record. They know that Officer McFadden thought there was armed robbery. And it is a reasonable inference that an armed robber is armed and dangerous. That's a reasonable inference to make. And Officer McFadden, I'm going to assume, was not Superman. And I'm going to assume that he was not under the impression bullets would bounce from him. And I'm going to assume that he's aware that 3 potentially armed men could overpower him and hurt him. And anytime any man goes up into a confrontation with other men, you are aware of the potential for you to be harmed. And maybe the word fear is not the correct thing. Maybe it's just an apprehension of potential harm. Would that help you out, Chillie? If we relabeled it from fear to apprehension of potential harm, he understood that he was in a position going up against 3 potentially armed men, that he could, in fact, be harmed if he left them armed. I don't like defending Terry v. Ohio, but this guy's so dumb. I feel like I have to, and it saddens me.
And push this argument for officer safety over your civil liberties, because the functionality of the Supreme Court is supposed to be to defend our civil liberties at all costs.
The function of the Supreme Court is not to defend our civil liberties at all costs. It is to define what the Constitution means. It's the court of original jurisdiction of suits between the states and suits by the states against the federal government. And it is the court of review for other federal questions and questions of diversity, I guess.
Defend the civil liberties that are your God-given rights. Listen to this next part.
Well, if they're God-given, I mean, why did we need people? Why did we need a bunch of dudes in the 1700s to write them down if they're God-given?
Carefully, Thurgood Marshall is going to...
And why did God only give them to the United States? Like, why didn't he give them to the whole world? Oh, I wonder if Thurgood Marshall is going to be racist now.
You have the best arguments there are as to why this case shouldn't even be in court. And then he's...
Oh, wow. Okay. He's going to give the best arguments as to why this... all right. It's kind of weird. Thurgood Marshall was born during slavery, or not slavery, but during Jim Crow in the South. Why isn't he getting the same treatment as these other justices?
That are your God-given rights. Listen to this next part carefully. Thurgood Marshall is going to give the best arguments there are as to why this case shouldn't even be in court. And then he's going to destroy Martin McFadden. He's going to destroy his character. He's going to destroy his ability. He's going to destroy everything about Martin McFadden. You have to listen carefully.
He's going to destroy him, and then he's going to join with the majority decision.
The thing in this case, this arresting officer testified, did he not, that he'd never seen anybody case a joint.
That is correct. He did so
He
testify.
also testified that he'd been on that same area for some 30 years doing the following things: taking for pickpockets and shoplifting.
That is correct.
So where did he get his expertise about somebody who might commit a robbery?
I think that he would get his expertise by virtue of the fact that he had been a member of the police department for 40 years. And by being a member of the police department for 40 years, I'm quite sure that even by osmosis, some knowledge would have to come to him of the various degrees of crimes.
Now we get intuition by osmosis.
Not at all, sir. Not at all. Not at all. I did not mean, I didn't mean to imply that, nor did I mean any disrespect by so using that particular term. I think that, for example, I, as a lawyer, around a particular office for a number of years, and I certainly must gain knowledge about various concepts of law that may come about from time to time.
There are exceptions to that.
I would agree with the court in these circumstances also.
It's a funny joke, right?
I actually don't get the joke, to be perfectly honest with you. But yeah, so amazingly, Thurgood Marshall points to the same thing that I pointed to, I think, in the first one, where Officer McFadden not having observed anyone casing a joint or making an arrest for anyone casing a joint over his career as a police officer is a strike against McFadden. But it's not a death blow because at the end of the day, they were armed and they were casing the joint. So like at the end of the day, his intuition was correct and he was able to articulate facts that could lead someone to believe that crime is afoot. That could lead a reasonable person to believe crime is afoot.
The thing is, though, Reuben Payne is correct. Reuben Payne is spot on in his analysis of learning policing, being on the job for 40 years. Remember, Martin McFadden's job up until from 1924 to 1954, 20 years, was to enforce black codes, which meant to instill...
Well, his job was to enforce all of the laws of Chicago, all of the laws of Illinois, and maybe some federal laws, but generally speaking, the feds would enforce federal laws. So,
fear in the black community, and to be suspicious.
I wasn't aware the black codes were in Illinois, but okay. I didn't know there was segregation in Illinois.
Of black people and to arrest them. After 1954, there's a no man.
All Officer McFadden did was arrest black people, apparently for his first 20 years.
Land from 1954 to 1964. In 1963, Martin McFadden says he's suspicious of John Terry. He doesn't like how he looks. What have you been doing for the 20 years before 1954?
No, seriously, Mr. Payne.
I don't know. Probably acting as a police officer. I mean, police officers actually interact with people of every race in their community, right? I'm guessing. I mean, I'm not saying that there aren't racist cops. I'm sure there are. I mean, cops are people and people are fallible. And, you know, some people are racist, some people are. I'm sure there are some racist cops. But that doesn't mean that just because you're a cop, you're a racist. I mean, there are black cops. Are they racist against black people? There are cops who are married to black people, you know? Does that make them racist? I don't know. Maybe Chillie thinks that it does make them racist. I don't know. Okay.
The point is that the only thing he noticed was a man leave from position talking to another man, and go across the street, look in the window, and go back. Now, number one, you'll agree that everybody looks in a public window is not casing a joint.
Agreed.
But they did do it twice or three times. How many times?
It was
not too clear to me, the record.
May I, then, in response to the Justice's question, indicate? First of all, and clarify this. His testimony was not that he didn't like them. His testimony was that he didn't like their looks. Now, I don't think that he meant by that any reference to pigmentation or anything else.
What? I think that he meant by that, when we take the entire record into consideration, the fact that this was in a downtown area, that these people were not continuing the regular flow of commerce of the other people on the street, and then Marshall says that they bared watching, would you say?
And anyone with two eyes in his head and was roughly...
Oh, well, this is a different thing.
Normal vision can look around him and see that there's a vast and permanent difference between the white and colored people. That is Abraham.
Is that Officer McFadden there?
Lincoln so wisely said a number of years ago, would forever prohibit them from living on terms of equality in the same society. That just in a nutshell
is this guy even from Illinois?
is the reason.
I think that he meant by that, when we take the entire record into consideration, the fact that this was in a downtown area.
What did your own court say he still did not?
Black folks hanging around downtown? No.
The reason.
I think that he meant...
They were in a downtown area, and then he cuts out that these people were not continuing in the regular flow of commerce of the other people on the street.
By that, when we take the entire record into consideration, the fact that this was in a downtown area.
What did your own court...
And the jump cut. And where did we jump from and to? I don't see a timestamp on here anywhere.
He still did not have probable cause for arrest.
As of this point, the trial court indicated that at this point that there was not probable cause for arrest. The appellate court did indicate that there was probable cause for arrest after the frisk took place.
No, I mean, we haven't frisked him yet.
That is correct.
So he didn't have probable cause to arrest when he approached.
I would agree with you.
He didn't get probable.
There's no gun evidence without the frisk to start. Yeah, we get it. And they said that because you can frisk someone on reasonable suspicion that they're committing a crime and reasonable suspicion that they're armed, then there you go. You have to have the both, though. Reasonable suspicion they're committing a crime and reasonable suspicion they're armed.
Cause to put his hand on the button.
he didn't get probable cause to arrest
him until he put his hand on the butt of the gun in his inside built pocket.
No, sir.
Counsel for petitioner says he didn't have it when he laid hands on him and turned him around.
I would agree with, he did not have probable cause to arrest.
Right.
I would agree that he would have probable cause to frisk or to lay hands on him at this point.
Probable causes change any cop's suspicion of you for officer safety. That's not what they're saying. That's not what they're saying.
Why? Because of the nature of the circumstances and protection of his own life.
He didn't see it go. He didn't say he saw it go.
The next words make Chillie shake. It's not the Coke. It's the words.
Bulging, anything like that.
No, he did not say that he saw a gun bulging. He indicated that they were casing.
He said that he thought bad things of them. End quote. But that's not a quote. What are you putting in quotes? That's not what he said. Hold on, let me back this up just a bit. I don't want to go back 5 seconds, although it probably would have been faster to go 5 seconds. Hell with it.
He didn't see it go. He didn't say he saw a gun bulging or anything like that.
No, he did not say that he saw a gun
Where is this quote coming from, Chillie?
bulging. He indicated that they were casing a joint for robbery, which implies a crime of violence, which implies that they have a gun, which implies a crime of violence, which implies that they have...
Which implies your rights are based on cops' thoughts. No. So if the cop can't get into court, because this all that matters is what you can prove or can't prove in court. That's where it all matters. So the cop arrests you, and you think your rights were violated, and the cop doesn't think he violated your rights. It doesn't really matter. You get in front of the judge, and you do your motion to suppress that evidence. You say, my rights were violated. Now, can the cop provide sufficient evidence to the judge that he had reasonable suspicion and or probable cause based on the nature of the violation that you're alleging? And that's when it matters. You're just because cops can do things, like a cop can always violate your rights. But whether or not a court will agree that he violated your rights, that's the big deal. And that's why it's the Supreme Court, not the Supreme Cops, who go to decide where the edges of your rights lie.
have a gun.
And then Thurgood Marshall will vote for Terry laws.
And then Thurgood Marshall does what?
Which implies that they have a gun.
And then Thurgood Marshall will vote for Terry laws.
Yes. And apparently there's a part 4. I wasn't given a link to part 4, and I'm not going to go look for it. Anyway, let's see if there are any questions going on. It took him 20 years to put all those posters in someone's garage. It took 2 decades. You think it'd be artwork? Yes, you would. He showed Terry versus Ohio. All right. Terry versus Ohio is based solely on suspicion of what someone could possibly do, not actually based on the actual crime. No crime was committed. No injured party exists. Well, okay. So again, Lively's reports, conspiracy to commit armed robbery is a crime. So a crime, once they discussed committing armed robbery, once Terry and Katz and the other guy whose name I forget conspired to do it and took a step to further their conspiracy, a crime has been committed. So yes, there was a crime committed in Terry v. Ohio. Beyond, and even that, the carrying a concealed weapon in violation of whatever Ohio state laws was also a crime. But it is based on the suspicion that crime is afoot. Now, that doesn't mean that crime is to be committed. It could also be reasonable suspicion that crime was committed or is in the process of being committed. So there you go. Someone has an honest mustache. Okay. Sorry for your arthritis. Reasonable suspicion they are lawfully allowed to carry a gun is no cause to search. Reasonable suspicion that they are lawfully allowed to carry a gun is no cause to search. Cop never had probable cause. Judge created the argument for a Terry frisk. Yes, the judges did create the reasonable suspicion standard there. And they're justices, technically, not judges. If I was black, I'm pretty sure being told how to be a better black American by Jose would irritate me. Probably would. And, okay. So I'm not seeing anything. Thing about Terry v. Ohio is based solely on. Yeah, we've seen this one. All right, so I don't see anything else that particularly is important or compelling to respond to. So I'm going to thank you all for stopping by and have a great afternoon.